There's two main tips I have for you. Number one, always tell the truth. Never make up facts. You're not going to win or win the case for us by your testing. The only thing you can do is lose the case for us.
Welcome to Between the Briefs, a podcast by Steno. We're here to bring you practical tips, expert insights, and real conversations about the pretrial process, court reporting, and the legal technology shaping the future of litigation. I'm your host, Adrian.
And I'm your host, Joe Stevens. Whether you're an attorney, paralegal, or just curious about how technology is changing the legal industry, we've got something for you. Each episode will break down complex topics, share behind-the-scenes intel, and talk to the people leading innovation in and out of the courtroom. So grab a coffee and let's get into what's happening between the briefs.
Hello and welcome to Between the Briefs, brought to you by Steno. We are your hosts. My name is Adrian.
And I'm your co-host, Joe Stevens.
In this episode, we're thrilled to welcome Michael Sigall, an associate at Seyfarth Shaw LLP. Michael specializes in representing employers in wage and hour class collective action claims, employment discrimination, retaliation, harassment, failure to accommodate, and wrongful termination. With years of experience, Michael has become a trusted advisor in business, navigating complex employment-related legal challenges.
Michael's experience extends across a range of industries, from startups to large, privately held companies. And his approach to employment law combines legal expertise with practical, business-driven solutions. He's also highly skilled in providing day-to-day counsel to employers on matters such as employee discipline, internal complaints, and workplace investigations.
Michael, welcome to the show. It's great to have you with us here today. How are you doing?
I'm doing great. Happy to be here.
Yeah, we're really happy that we were able to be intro to you and ultimately have you on the show. So I would love to take our audience right to the beginning. Tell me a little bit about yourself and what got you into law in the first place.
So my way to the legal field is probably unlike anyone else's. I went to college. I had no idea what I wanted to do. Right after the earthquake happened in Haiti in like 2010, I actually volunteered in Haiti for about 6 weeks. I stayed in a tent camp with this NGO, and there was a lawyer there, and I became friends with the lawyer, and I'd never thought about doing anything in the legal field. Their legal work had nothing to do with anything going on in Haiti. They just wanted to give their time back to the community. And I kind of piqued my interest. I went back to college for my senior year. I took 2 classes through law school and really liked it, because going back to when I was a child, I loved doing puzzles. And a lot of what I do on a day-to-day basis when I write briefs and things like that is kind of figuring out how cases fit into a puzzle, or how, you fit a case into a set of facts. So that's kind of how I got there. And I guarantee you no one else will ever give that answer, because it's very unique.
That's a great answer, though, Michael. I'm a lawyer as well, and I'm always intrigued at people's path to the practice, especially if there's some real outside force, like what you just described, that really sort of singular service experience, it sounds like. How has that carried into your practice when you're in your day-to-day sort of employment law practice? Do you think on it? Do you reflect on it? Does it sort of undergird your sort of social purpose?
I think it does in some sense. Like I firmly believe that the practice of law is based off of relationships, not only with clients, but also with like opposing counsels too. And going back to, first meeting this friend of mine that I met in Haiti, he told me it's like basically just forming relationships, and kind of, everyone's advocating for one position or another. And, the legal field is filled with people just, I don't want to say screaming at each other, but having so many disagreements from time to time. And it can be something that's much more collegial. Yes, everyone has varying perspectives, and yes, everyone thinks their client is right and the other side's wrong. But, I try to treat my practice in a way that I respect the other side and give them the decency and let them be heard, because I feel like most people should be heard.
I love how you mentioned allowing even your opposing counsel to be heard, even in the courtroom, right? How do you take that approach when it comes to your clients? I think a lot of these clients of yours are probably in distress, right? Just went through a traumatic experience either with their employer, whoever it may be. What type of techniques do you employ to make sure that they feel heard?
I treat them So my parents always tell me, treat people like you want to be treated. So I essentially treat them as if something horrific just happened to them. I, console them. I mean, a lot of not necessarily Fortune 10 companies, but a lot of smaller businesses that this may be their first time ever getting sued, and kind of listening to them and telling them that they're not alone. We're in California, employers get sued all the time, and kind of making them feel like that they're not in this by themselves. Yes, it may be a small company. Maybe they have, 100 employees, or a startup that has 15 employees, but there are plenty of other companies throughout California that are in the same shoes as them, or sometimes far worse, because they could have a far, far, far worse claim against them rather than something very small.
Michael, for our audience, just why are companies getting sued in this? Like, what are the most common suits that are brought against these companies? And then what do you spend most of your time doing as an employment lawyer?
So I'll break it up because there's two buckets. There's the single plaintiff bucket and then the class and representative bucket. I would say in the class and representative bucket, more and more cases are PAGA cases now. So under the Private Attorney General Act, less so class actions, because most employers now have arbitration agreements with class action waivers. There are instances where some employers choose not to have them. It's their decision, or there's case law in California that's come out that basically says that the transportation exemption doesn't apply, so the class action waiver doesn't hold grounds. So in that bucket, it's PAGA cases. Like I can't even tell you how many PAGA cases on a day-to-day basis. And then on the single plaintiff case, or single plaintiff side, it's a lot of definitely just wrongful termination claims, and then everything that roots from that. So there's always some basis for the wrongful termination. So discrimination, harassment, or also whistleblower retaliation is very common, where someone is claiming that they complained about something and they were retaliated against with their termination. What do I do on a day-to-day basis? Mostly with PAGA cases, it's evaluating the claims for the client to figure out exactly if there's any merit to it, and kind of advising the client, do they want to litigate this or do they want to mediate? Because PAGA cases and class cases are very expensive to defend if you want to defend them properly. But if there's clear liability with something, such as a regular rate of pay issue, it makes so much more sense to just mediate the case, because you're dead to rights on that. And it's very nuanced, and not almost all, but I would say a fair number of employers do it incorrectly. And on the single plaintiff side, it's more so interviewing people and figuring out exactly what happened, because there's always, I want to say 10% of the time, there's probably some merit completely to the claims. And I would say 80% of the time, there's some kind of, I'm trying to think the best way of saying it. 80% of the time, there is a meld of both sides, that there's some truth to what the employer is saying and what the plaintiff is saying. And then there's the 10% of the time, which is the horrific cases where the employer just completely screwed up and did everything wrong.
I'm curious, you mentioned that a lot of these businesses, even if the small ones, right, the mom and pop ones, startups, come to you kind of in distress because now they're getting sued. What do you think they can do to be more proactive, or anyone listening as a business owner do to be more proactive about this, so that when they come to you, it's not all in shambles?
I would say the first thing is always have employment documents, like a handbook, or, some policies that kind of have a roadblock necessarily about, anti-harassment policies, anti-discrimination policies, and things like that, and actually have employees read the handbook, sign the acknowledgement, because a lot of the mom and pop shops early on, what they're trying to do is just essentially make money, and then, putting out all these fires on a day-to-day basis. But if you have the policies there, that can kind of generally be something as a guidepost for you to look back on and say, Supervisor Joe Schmo was harassing Sally. We counseled him, and then he acknowledged these policies that he wasn't supposed to be doing this, and so forth. These businesses get in trouble when they don't have any policies. So it's essentially, I want to say, me and plaintiff's attorney, or any plaintiff's attorney, can come and say, look, you have no policies whatsoever. Your office basically allows for this to happen, no one has ever counseled on it. That's the best way to prevent it. And then also, as going back to what I said before, not everyone has arbitration agreements, and arbitration agreements generally can dissuade some attorneys from taking the case on, because plaintiffs' counsels generally like juries because they give more adverse rulings.
What about this? I mean, when you think of human resource departments, when you think of policies inside a workplace, like those are usually, if they exist, these are the first sort of points of interaction of an employee with their employer, generally speaking. Orientation, here's our handbook, here are our rules. It's sort of like all of the things that you just have to check so that you can go on about your job in a way. I'm trying to figure out how, it's obviously very important to have these things, but like, what about the places where they're sort of sitting there being like, we're just so small that our policies are sort of intuitive, right? Like, we don't want you to be rude to people at work. We don't think that we tolerate any sort of discrimination, sexual, racial, religious, whatever. Like, do we have to be explicit about that? Is that something that really does need to be written down?
Doesn't need to be explicit, but if you're going to have it verbally done, let's just say during an orientation, just have some document to memorialize it. So that's what I tell all clients is the most important thing is a timestamp memorialization of exactly what occurred. It's as simple as sending an email to yourself, because emails live forever. Everyone knows that now. And an email has a timestamp on it. So yes, for a small company, if you say, we had an orientation today with the entire office where we explained all the employment policies, this is what we said, blah, 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 blah. It's something that can be referred back later on if there's a litigation where Exhibit A is on April 30th at 1:17 p.m. I sent an email to myself that said X, Y, and Z.
Is that the same with, like, okay, I had a meeting with Adrian today, and so to memorialize the sort of outcome of that meeting, I say, Adrian and I spoke earlier today, and I just want to follow up with you, Adrian, and make sure that we have this corrective path forward, and documenting sort of employee interactions like that when it comes to like course correction or behavioral correction?
Correct. I have a ton of friends that have their own businesses, and I tell them all the time, the best thing to do is memorialize everything and send a confirming email, because it gives, in your example, Adrian, the ability to respond and say, no, none of that's true. If they don't respond, that's kind of them conceding to the fact that everything was true.
Adrian, you can expect an email later.
All right, let's go. Fighting words, Joe. Now, Michael, I would love our audience to learn a little bit more about yourself. You've had a very successful career, all the way back from Betts to Deck Law Services to now Seyfarth and Shaw. What would you say some of the traits you kind of embodied as an attorney that helped you gain the success?
I would say I've worked really hard. Being a lawyer is probably one of the most difficult jobs, because you're balancing so many different skills and having to have the most I'm laughing thinking about it, but like everyone has always told me going into law school and becoming a lawyer, attention to detail is the most important. And understanding people's expectations. As you said, I started off at Bezedic. I volunteered there for a little bit. I went on, I worked at Wolf Rifkin, which was a smaller firm here in Los Angeles, where I only worked with a few partners. So there's only certain expectations of those partners. Whereas at Seyfarth Shaw, I work with like 13 to 15 different partners, and each partner thinks differently, and being able to understand that and appreciate that and not feel bad if I do something wrong because one partner may feel differently than another partner. It's kind of understanding that this job, you're constantly learning, and every single day I'm learning something new. It could be something as subtle as someone liking one space after a period rather than two, or something as big as, addressing when drafting a motion for summary judgment, including addressing the whistleblower retaliation claim rather than the retaliation claim, because structurally it is better for the judge to understand that claim prior to the retaliation. It's kind of understanding the nuances has been what has helped me succeed the most, because I can adapt myself. And I kind of call myself, I tell it to people all the time, I'm kind of like a chameleon. I can pick up what people want in need, and that's the best way I could do my job.
In your career, Michael, obviously there's been a lot of changes, whether it's on the tech side, whether it's on the sort of the regulation side. I'm interested to know sort of what area of employment law is experiencing right now the most rapid sort of evolution.
I would definitely say class actions and PAGA cases, just because the law changes so often in interpretations of the statutes, and the legislator just doesn't necessarily always change the statutes from time to time. So we're still working off case law. Uh, the great California Supreme Court loves to make these decisions that overturn great Court of Appeal decisions, in my opinion, for employers and change the law. Like it's a constant struggle, I would say, because these decisions can vastly change from time to time. And it's just me being kept up to date on exactly what's going on with all these cases. I was attracted to employment law because I liked how everything's changing from time to time. Like I could write a brief 1 year and the law could be on my side. And 3 years later, the law could change just because it's the nature of how courts interpret the law. 4 years ago, I could have never arbitrated a PAGA case. But now, because of Viking River, the U.S. Supreme Court decided that I can compel arbitration of individual PAGA cases, which at the beginning of my career was never there. The single plaintiff cases, I don't see them changing that much from time to time. That's just maybe because I just pay more close attention to the PAGA in class action, case law that comes out. But the main thing that changes there is the graphic nature of some of the single plaintiff cases. It's just,
Yeah, I could definitely see that being also kind of emotional, kind of an emotional toll. Like you mentioned, the graphic nature of some of them. How do you kind of deal with that if you have a client coming up to you and they got quite the story, but you got to kind of take that all in and then leave with it. So how do you deal with that?
uh, so the graphic nature of some of the things, it doesn't faze me. Both my parents were physicians and, were around blood all the time. And I've never been like, blood doesn't do anything to me. I joke around with my wife all the time about that. So I'm like, maybe I don't feel any when I read a new complaint and I see something that's could be considered graphic, I just it goes in 1 ear and out the other. And I wait till I actually speak to the client or the perpetrator, I guess you can say, to see if there's any truth to it whatsoever. Sometimes I say this like, I couldn't even come up with these facts, so it must be true. But it's once I hear the facts and I think it's pretty bad, the first thing I do is always speak to our client and tell them, look, this can get bad really quickly. If this is true, we should try to resolve this sooner opposed to later, because in California, there's a attorney's fees provision for prevailing plaintiffs. So going to trial, even though 98% of cases don't go to trial, it makes sense to resolve really, really bad cases early on.
What about not necessarily the graphic nature of the cases? I do a lot of criminal law, so we get our version of that too. What about less when it comes case by case, but more? I mean, you're obviously dealing with a lot of socially divisive issues too, and I wonder if that impacts you in a different way. If there are times where it's hard to sort of maintain your objectivity in a way, or if that affects you differently than the facts of the actual case itself.
It never affects my objectivity. I was fortunate enough when I was younger to my parents exposed me to everything, like to many different cultures, travel and things like that. So I've been open to so many different kinds of religions, ethnicities, languages, and things like that, that I don't really have any issues in that way or another. Yes, sometimes when I read a complaint and as Adrian asked me, it can be horrific and I'm like, oh, wow, that's pretty bad. Yes, I do have a bias, but at the same time, every person has the right to an attorney, or every company has the right to an attorney, and I'm there to defend them as best as I can through the time of, which I hate to say it, almost all cases were resolved prior to trial. So through the resolution. And I try to do my best, but when I tell people, some people get bogged down in the facts, and I tell junior associates all the time, we can't recreate the facts. We're given the facts. We're not the ones who did anything wrong. It's, whoever's mentioned in the complaint. So we're just there to essentially assist them and try to get this resolved as soon as possible, or, advocate for them through trial or through an arbitration.
I would love to know your take on how you're seeing technology change employment law. Are you seeing AI kind of disrupt the space at all, or have you seen it largely untouched?
I'll answer this more from my firm. Uh, I think AI is a tremendous help. I I never thought it would be this big of a help. I know a lot of people internally in my firm don't use it as much. I use it a lot through Steno, actually. Um, their Transcript Genius, I think, is one of the greatest things I've ever experienced before. I've offered other things I think would be even more helpful down the line, because I'm sure there's an AI functionality that, maybe a year from now that would be able to do it. But the nature of how I can ask this AI functionality about something from the transcript, or compare multiple transcripts at the same time and see where witnesses corroborate each other or go against each other, is probably one of the most useful things I've ever experienced in my career. Um, but I wouldn't say everyone in my firm agrees with me, because not everyone in my firm is open to using AI. I think there's kind of a, I don't even know what to say. It's like when computers first came, there's a trust issue. I think when computers first came out, people were like, why am I going to use a computer? I can just handwrite everything. And it's kind of more the older generation not being as open to saying, oh, let me use this cool functionality that, will take 5 minutes, rather than reading an entire depo transcript.
Another sort of tech insertion into the workplace is obviously the rise of remote work. And I wonder how that has affected the sort of employment law landscape.
Yeah, I mean, it's a great question. I think it affects more so in the sense of employees feel like it's better for them because they can be at home more, and, they don't have to commute to their office. It also, in a sense, creates less of a hostile work environment atmosphere because everything's remote. So it's harder to make those claims. But at the same time, because there's no verbal interactions with each other, it's mostly digital. I see more claims rooted off of emails and people taking emails the wrong way, because people can come off the wrong way when writing an email compared to when they're speaking. And because of that, people are feeling more, rather than a hostile work environment claim, it's more discrimination, because if you're in a protected class, and I had a case recently where someone claimed that they were discriminated against because of their race, and the people didn't even know what they looked like because they never had a Zoom conversation, a Zoom uh, conference before. But it was just the basis of how the emails were written to them, and they felt like the person was definitely taking a sword into them and so forth. So, I mean, with remote work, yes, I agree. There's some nuanced nature with that, but also it's different.
You touch on a really key point there, and it's that it can be very subjective at times, right? So how do you take a concept that or a story that is very subjective and then make it objective facts when you have to present it to a court or a judge? Uh, how are you able to portray that in a successful manner?
I talked to multiple people. So going back to what we were talking about with single plaintiff cases, I always interview multiple witnesses who experience, let's just say, an alleged harassment, and get their rendition of the facts. And I never change the facts whatsoever, but I take various people's opinions about what happened and then present them in the most objective way possible to the court. So for instance, if I'm drafting a motion for summary judgment or something, and the claim has to deal with harassment, I'm going to start off with the facts that are most objective that the witness told me, in order to support the reason why that this case has no merit and it shouldn't proceed. If the attorney is really good on the other side, if some of my facts are objective or subjective, they will bring those up during their opposition, then I have to address it in the reply. But I mean, I can only do, as I said, as best as the facts that are given to me. So sometimes You don't have the right cards in your back pocket.
Right. You can only sort of obviously play the cards that you're dealt. When it comes to, I mean, we hear this all the time, right? You learn some things in law school, but then do you really learn how to be a lawyer in law school? And I'm on your end, what are things you wish you were taught in law school, or what are things that you think people should be being taught now that you and I weren't taught when we were in law school?
So I learned a lot about legal writing definitely in law school. I think that was the number one most useful thing, because the writing that I did in law school is nothing like I did in college. But I think more oral advocacy, more, you know, no one ever told me to take California civil procedure, and it's not a requirement for the bar, but I think that is extremely more useful than federal rules of civil procedure, even though I still use it every day, the federal rules. Um, but I think mostly, classes on depositions, how to ask questions, how to defend a deposition and things like that. There's this particular art to it, and an art to taking depositions, because people think the first time you're taking a deposition, you're just asking questions. You're really cross-examining the person, and you're trying to get out the facts that are best for you and getting them to say yes or no responses once you get the narrative that they said, and having them confirm it, so then you can use that later on for a motion for summary judgment, for trial or arbitration. I didn't learn that until my second or third year of practice. I would go into depositions and it would be like, so, please tell me everything that happened relating to you missing your meal periods, and not getting the necessary things that I needed, um, which I didn't learn in law school.
I would love to dig into that a bit more with the depositions. Do you feel that digital depositions, or we're more in a digital age, so do you think the digitization really of depositions has made it a little bit more difficult to extract the information you're looking for out of your witness?
When you say digital, do you mean the
The
remote
remote
deposition?
aspect of depositions, yes.
I think that I was very apprehensive to them at first. I was very worried that the depositions weren't going to work, and I wasn't getting the testimony, or the court reporter wasn't getting affirmative answers that I wanted, or things like that, because of internet connection or so forth. But over time, I get real time when I do remote depositions now. So I can actually see on a separate iPad that I've hooked up that says what the answer is, so I can confirm all the time. I also personally like the remote depositions almost more now, because in the in-person depositions, if I'm giving someone an exhibit that's 1 page, or let's just say 5 pages, the person sometimes is focusing on all 5 pages when I only need them to focus on page 3. If it's 5 pages, I can pull it up on my screen and say, look, I'm going to cycle through all 5 pages, but I only want you to look at this one paragraph on page 3, and I'll zoom in on it for you. So they're completely focused on that, rather than them being focused on, oh, this thing says all these other things, I need to pay attention to this. I think it streamlines a lot, and people also, the deponents feel so much more comfortable being at home. Like, I can tell the difference, because I don't think I come off as someone who's really mean or angry, but sometimes people walk into a room with me and you can't tell, but I'm 6'7", and I kind of come off as this big towering person. So they're a little scared of me. So I have to kind of butter them up before the deposition starts. When it's just through Zoom, for me, it's much easier, because I try to treat it like it's a friendly conversation with them. Like, I'm just here to get the facts. So personally, I think it's been great.
Do you always want them to feel that way? I mean, one of the things that I always think of in my practice is there is the presence of being in court, the difficulty of being sworn in and standing up, and everyone's looking at you. And sometimes the witnesses that I'm cross-examining, I want them to understand the intensity and the weight behind what they're saying and how they're saying it. And that changes the game a little bit.
This is a garden variety legal response. It depends. In my class action cases, when it's just about people complaining that they didn't get their 30-minute meal period, it's very low stakes, in my opinion, with regard to their testimony. It's very vanilla. And I feel like they're more comfortable being at home. When it's something serious, like they're saying Joe harassed me, was constantly touching me inappropriate, things like that, and I know, like, I have a video or something to show them that they're completely lying, then yes, I agree. It's much better for it to be in person, for me to be face to face with them, me showing them, like, bringing an iPad and saying, "Look, this is what you said happened on this day. This didn't happen. You actually touched him," something like that. So yes, I do agree. It depends. I'm thinking more. I do mostly class action cases now, and all my class action cases are vanilla facts. So there's lower stakes with their responses as the facts are much more vanilla. There's higher stakes in that the case it has a much larger value because it's a purported class action.
When it comes to the deposition, have you ever had to do coaching with your client and telling them like, "Hey, only answer the question that you were asked," or what does that look like for you?
Yes, always. I was prepping someone yesterday actually, and they've never been deposed before, and I tell them there's two things. There's two main tips I have for you. Number one, always tell the truth. Never make up facts. You're not going to win the case for us by your testimony. The only thing you can do is lose the case for us. So you always want to be truthful. And number two, only answer the question being asked for you, because a lot of people like to ramble and talk because they think the deposition will end quicker. It actually causes the deposition to go longer because you're bringing up more facts that aren't even related to the claim whatsoever. So if you just answer the question being asked, you'll be out of there much sooner. And I know, especially with someone who's never been deposed before, they want to get out of there as soon as possible because they think their job, this is related to their job. And if they don't do well, then their job's not going to like them anymore, blah, 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 blah. So
Michael, one of the things I'm always interested in, you mentioned we kind of kicked off the conversation, you talking about making a decision to go to law school after your time in Haiti. What else do you bring into the practice that sort of has nothing to do with the law? Like, for example, I worked in restaurants for a while, and I think so much of like the hospitality side of the work that I did and how that applies to being in court or the courtesy that I show opposing counsel, whatever it might be. Do you have something like that that is non-legal that you actually bring into your practice?
going to the restaurant thing, I have done a lot of restaurant litigation. Every single time I go to a restaurant, I think about my practice and meal periods and rest breaks. That's going the other way. Uh, I I I generally bring a lot of sports analogies into my practice because I love sports. In my office right now, I have like 3 replica LA Lakers championship rings that unfortunately they're probably not going to win one this year, so I won't have a fourth one. But I try to bring in a lot of sports analogies to dumb down things for clients, and also going back to Adrian's question about deposition prep, also depositions, and kind of using those examples of explaining what happened in a game or something and how to kind of go over facts that may be more appealing to someone than them talking about their meal period policy or something like that, kind of as a practice point for them. So they're more comfortable talking about basketball first, and then we can talk about the serious stuff, which is about the meal period policy.
Great way to put it into layman's terms, help them really understand the full scope of everything. I would love to let's go to like the future here. What do you think is going to be the biggest challenge for employers in the next 5 to 10 years? Because we're seeing technology change very rapidly. The way that employers are working with their employees, things are changing. So do you envision a different future in 5 to 10 years for employment law?
I do. I do. This goes back to one of my responses earlier, but I see the changes more with how the law changes, um, and how certain previous rulings are interpreted by different courts and how they'll affect employers. Like for instance, for years, if I had a warehouse client and they brought a class action complaint against the employer, I would always move to compel arbitration and say there's a class action waiver, so there should just be a individual action, and the case would go away for, you know, ten, $20,000 or something. But since the Supreme Court, I think 3 years ago, the U.S. Supreme Court had this case called Saxon versus Southwest Airlines, it kind of expanded this transportation worker exemption. And then the good state of California has taken it even a step further where warehouse workers are brought into this exemption. So the FAA doesn't apply. And these cases that generally would go away for $10,000 to $20,000 are now, if a client wants to get out of it, it's not a single individual case anymore. It's a class action case that needs court approval. So I see more and more legal changes mostly that are going to affect employers more than anything. I think AI could be replacing jobs and things like that in the future. So yes, that could affect, people bringing claims that they were discriminated against because AI is taking over their job. But I think the biggest issue is probably going to be just jurisprudence changing.
What about things like the gig economy? I mean, or I don't know, just the evolution, the insertion of technology into this field obviously is just so, it pulls in so many different directions. When I think of the discussions that really took place around like the gig economy, like a while back, I'm wondering if that is still something that is just under-regulated, over-regulated, something that provides challenges to the employment law landscape?
It does with the gig economy, but I'm seeing the gig economy being changed now with Waymos driving around Los Angeles all the time without drivers. I mean, I know Uber, I think, signed some wasn't a licensing agreement, some agreement, I can't remember with what company, about having driverless cars. They're not going to have to pay drivers anymore to drive these cars. And, the gig economy is going to change completely. And in my opinion, because if you have Waymos essentially driving people around, Waymos can be doing Postmates. I mean, there's already these little robot things that if you're in a close radius and you're ordering takeout food, they deliver your food, and it's taking work away from other workers. So, I mean, it's all evolving, and technology is a big influence of that. And never in my lifetime did I think I would get in a car that didn't have a driver and I would feel safer than actually in a regular Uber or something, but I do.
For the record, Michael, in LA, that might be true. I live in Lubbock, Texas, and we're probably 40 years away from any of that happening.
Look, I would have never thought LA, that has so many cars and so many people, that we would have Waymos before nearly everyone else, but it blows my mind.
Now, Michael, we always ask this at the end of the conversation, and that is, what is your hottest take on the industry right now?
This is no secret based off everything I said, but AI is going to literally transform the entire legal industry. I think AI at a certain point may or could replace, I think at a lower scale, paralegals, and then move on from there. I mean, I have friends on the plaintiff's bar who tells me they don't even know. I know nothing about AI compared to what they're doing with AI. They have AI that are doing discovery responses for them. They have AI doing depot outlines for them. They have AI doing all these things. I just think that is going to, AI over the next 10 years, I think is going to revolutionize the whole entire industry. I don't think it's necessarily going to take jobs away from associates or, partners or things like that, because you need the associates and partners to have the relationship with clients. I just think it's going to change a lot of the lower level positions in law firms. Could make law firms more profitable because they have less overhead, but at the same time, it's going to revolutionize how we interact with people on a day-to-day basis.
All right. Well, that is a great hot take. Thank you, Michael, for coming and joining us here today. And thank you to our audience for tuning into Between the Briefs, brought to you by Steno. Of course, special thanks to our guest for sharing his valuable insights into employment law, defending employers in high-stakes litigation, and creating effective workplace strategies. And of course, big thank you to my co-host, Joe Stevens, for another fantastic conversation.
Yeah, thanks to you as well, Adrian. And let's be sure to subscribe so you never miss an episode, and stay tuned for more thought-provoking discussions at the intersection of law, technology, and innovation. We'll see you next time.
Up next on Between the Briefs.
And you better have a plan for where the puck's going to be in the next 5 years, or you're going down no matter how good you are.
Stay tuned for the full interview coming to you soon. Between the Briefs is brought to you by Steno. To find out more about Steno and how we combine exceptional court reporting and litigation support services to deliver a superior litigation experience, visit steno.com. That's STENO.com. And then make sure to search for Between the Briefs in Apple Podcasts, Spotify, or anywhere else you get your podcasts, and click subscribe so you don't miss any future episodes. On behalf of the team here at Steno, thanks for listening.